1 and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the station message line at 936 647 3776 to take your first step into the radio world.
You're listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Toni and Cheryl. Toni, Lynn Collins, and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys, and we come to you every Tuesday from 12 to 1 p.m. You can listen to us on irlonestar.com, or you can listen on 104.5 or 106.1 Conroe's FM, and you can watch us live on Facebook, and you can even send us messages on Facebook if you have questions about what we're talking about. So today, Toni and I are going to talk about depositions. How are you doing, Toni?
I'm fine. I've had ups and downs this week. Watching during Lent all of these shows on the life of Jesus, and then Unplanned just came out, and so I'm overloaded with how good people are supposed to be, and we're in a profession where people aren't that good.
Yeah, no kidding.
It's like so frustrating.
Yeah, it's kind of like the police. They see the bad side of a lot of people,
Mm-hmm.
and we hear all the facts.
They're trained to protect us, so they see that like, oh, that's a threat. And the reality, it may be they're not a threat at all. And of course, I do a lot of criminal defense, and that's frustrating for me a lot of times because I really like police officers in general, but I also get frustrated because a lot of my clients are falsely accused.
Mm-hmm. Yeah, I see the same thing. Well, so today we're going to talk to our listeners about depositions. Just kind of a broad overview. Depositions take place as part of the discovery process in a lawsuit. And you and I were talking before the show. Every time I've done a deposition, my client is just scared to death.
Mm-hmm.
So I just think that our average listener out there would probably really hate the thought of being deposed.
If they even know what that is. And I'm just going to say this real quick because I had to look it up. I mean, I always knew what kind of in the back of my mind what depositions were. I guess even watching old World War II movies, somebody's got the light on them and they're shining on, they're asking questions. That's more of an interrogation.
Right.
But a deposition is basically
Well, clients feel that way.
It is. No,
Yeah.
it is. It is an interrogation. There's no question about that.
Right.
Because you can't leave.
Mm-hmm.
If you do, it's going to look, you're going to be
you're
in
in
contempt of court.
Yeah.
Right. So anyway, deposition, the reason that we have depositions is to find out what the witness knows and to preserve that witness's testimony. The intent is to allow the parties to learn all of the facts before trial so that no one is surprised once the witness is on the stand. But I love the element of surprise many times. So I'm actually a proponent of not having depositions because for all the reasons that we'll discuss, I like to be in court and have a judge there and a court reporter. It's less expensive because you've got the government court reporter paying for it. But for a lot of reasons, I prefer to forego that form of discovery because I really prefer the element of surprise. For the other side, not for me. My clients usually have very little to hide. But I will also add that if, as we recall in this climate, that that very recently Trump has gone through, President Trump, he was under the microscope, or he was under a lot of pressure under this what he calls the collusion delusion,
Right.
and they wanted to not to talk with him. The Congress wanted him to go and answer some questions, whether it be before just the investigators or the prosecutors or the appointed counsel or whatever. And his attorney, Giuliani, and the attorneys he had before that did not want him to go forward and do that because he, just like the people before him that got in trouble, Manafort and the rest,
Right.
you say things that are not relevant to the case that can get you in trouble. And several of them, I believe, were charged with or went to prison or will go for perjury. and they didn't even know they were committing perjury, from what I could see.
Right.
But that's what you may have that element or that disadvantage if you go to a deposition, because you may say something then, and in all honesty, you may say something different in trial because it's asked a different way.
Yeah, absolutely.
Okay, but anyway, now that was just what I was going to say about depositions.
Okay. Well, Toni, depositions are important, more important today than they have been in the past, because only 3 to 4% of lawsuits actually make it to trial. And so deposition, and you and I were talking about this too, deposition is a lot like being questioned on the stand.
Yeah.
And
Well, you're
so,
being questioned under oath.
right.
So it is like being questioned on the stand. In fact, when you start a deposition, you tell them this will you actually your verbiage is will you tell the jury? I mean, that question always comes out.
Right.
Will you answer this? Will you tell the jury this? Will you tell the jury? And there's no jury there.
Yeah.
Obviously, it's just you and me, like we're right here in the station.
But it's going to be read later by a jury.
Right, and many times, in my own experience, those video depositions will be shown to the jury, and so you want to look nice if it's a videotape, because it may be you may just think you're going in for a discussion, and lo and behold, it's going to be for 12 people to see, and the bailiff and the judge and everybody else, and it comes in. And you may not even have lied. It's coming in because they're trying to impeach you with whatever you said in the deposition. You may not even have lied, but they may say you did. And it's ridiculous. So I think it's all a game. But anyway.
Okay. Having said that, 3 to 4% of cases actually make it to trial. And so the deposition is really used to dispose of cases in a lot of circumstances.
Yes.
So let's talk about who can be deposed and where the deposition takes place. Okay, any person or entity with potentially relevant information. This doesn't have to be parties to a suit. And by parties, I mean the person who brings the lawsuit that we call the plaintiff, and the defendant, who is the person, individual, entity, corporation that the plaintiff has brought the lawsuit against. So anybody with potentially relevant information. And I think that our listeners will really appreciate your comments about Trump after we lay out some of the basics. So potentially relevant information, and it includes non-parties.
Right.
It's not just the parties.
Right.
And they generally take place in a place that's agreed upon.
Yes.
Okay.
Well, generally, the party that, if it's the defense, if the defense has counsel, it's going to be the defense's office. So they try to bring it to your territory, and there's a lot of limitations about this. You can't depose somebody. I mean, and that kind of gets into the ways that that would prevent you from having to be deposed. And one is if they gave failure to give reasonable time to respond to the subpoena, because you have to subpoena third parties. You have to give a notice of deposition, and then if you're not a party to the suit, those are for parties. Right.
And if you're not a party to the suit, then they've got to subpoena
They actually
you.
have to be served notice to appear. And so a lot of my clients, and they're not my clients because they're in a lawsuit, they're my clients because they've been subpoenaed to be deposed or as a witness.
Because they may have relevant information about
And
the suit.
Attorneys have attorneys all the time. If you subpoena an attorney to come to trial, they'll bring their attorney. So just like you're going to trial, a person needs an attorney for a deposition almost all of the time, I'm going to say, because you don't know what they're going to ask you. A lot of times you have an idea, but you don't know. So it's a good idea if you've been subpoenaed to come answer questions at a deposition that you have an attorney present.
Absolutely.
But failure to give reasonable time to respond to subpoena if there's documents is one way you can get out of it. And not say get out of it, but that would be, it may be legitimate. You don't have time to, they can't tell you, subpoena you've got to show up for a deposition the next day and bring all these documents.
Right.
Obviously, it's going to be.
That's not reasonable notice.
Doctors all the time are subpoenaed to come testify for personal injury suits, and they don't want to do it because they're not making any money, and they're not being paid to be there. It's a hassle to be subpoenaed, and so they'll usually have their hospital attorney or their attorney file a motion to quash or whatever because they haven't given reasonable time, and that's a legitimate reason that the judge will grant it.
Grant that you don't have to be deposed.
Right,
Yeah.
a motion to quash the deposition. And I think I'm getting a little bit ahead of myself, but if you file the notice within 3 days of receipt of the notice, it's automatically quashed. So right when if you get a notice and your schedule is in conflict, or for whatever reason, if your attorney or if you file a notice to quash, it's automatically, and I believe it's Texas Rules of Civil Procedure 199.4. I can't remember the exact number, but whatever the statute is, it's automatically quashed just by filing that. Unreasonable travel requirements, such as being asked to drive over 100 miles to a deposition location. That is a reasonable reason for the deposition to be quashed and reset for a more reasonable location. And just like our station manager is now offering through the station.
He's thinking about it.
Well, if
which
he
we
does
think is a
offer it,
great idea.
and
yeah.
if it's in Montgomery County, he's at a central location, and there would be no argument.
Well, but finish that sentence. He's thinking about offering a recording deposition here in the studio.
Right.
And and that's what I was just telling him.
Station
It's a
manager Dick, what do you have to add about that? Anything?
central location.
Yes, it's a service. We're opening up another studio behind us that's more controlled production. And one of my ideas right then, I didn't know if there's any legality to it, but I was like, we could have a perfect place for depositions because it's neutral. It's downtown in Conroe, Texas,
You're
where the
across
courthouse,
the street from the courthouse,
from the county courthouse
basically.
seat.
And I really like that because in Montgomery County is fairly large, and if you have a witness that's over in Magnolia on the far end to the west.
How
and,
far is that from here?
Magnolia is about, I want to say 40 miles maybe if you're at the far end. And in Montgomery County is a lot of rural area.
Mm-hmm.
And let's say you've got, but the land the attorneys are all in Willis. So you may have over 100 miles from one to the other. Location is important, and this is a central location right here at the courthouse.
Right.
So that's another reason that that you can argue to the judge that they should quash the deposition, and why attorneys should agree with each other where it should be held before sending the notices out. It's just a lot of ridiculous paperwork. And another thing that you said, and then I'm going to back off and let you kind of talk more about the deposition itself and the things that you need to add, is that not everybody can be deposed, or there's an argument against it. And one of the big arguments is the invocation of the apex doctrine. And I'm calling it apex. It may be,
It's still apex.
it may be, what did I say? Enunciated a different way by somebody else. I call it apex, tomato, whatever. It's when the president or in an organization like Chase Bank, a large corporation where you want to depose the president, like for an example, Century 21, you want the highest owner broker when really the people involved were somebody lower. Now that's a good example of why that wouldn't work, because with a broker, the broker is also always going to be responsible for their agents. So you would always be able to depose a broker for a real estate conflict. But let's say you were suing Walmart. You couldn't bring Sam Walton. I'm not even sure if he's still alive.
I don't know.
Okay,
He's
that's a
not.
really good reason why you couldn't
Right.
depose him. Death. But
Or one of his kids.
you couldn't bring somebody who was a CEO or like Trump, let's say, if it was one of his organizations in, because they are too far removed from what's actually going on. They wouldn't give. It would be for harassment for that. And the courts, there's a rule of law, and there's a lot of statutes and that will prohibit. I don't want to say statutes. It's a rule of law in the Supreme Court, in the United States Supreme Court and Texas Supreme Court, that prohibits you from bringing in
The apex.
under the apex auction somebody that really is so far removed that they have nothing to do with the case.
Yeah, they don't have any knowledge of the relevant facts. They just run the company.
Right.
Okay, well, just some general uses for a deposition. It's gathering information. It secures testimony. You just went over some of that, Tony. Preserves testimony for trial. It limits testimony, and it gains admissions. And that's really the goal of the attorneys that are deposing, who we call the deponent.
Right. And list out the reasons why, if you have a list of them again, why it is depositions are good. What is the purpose?
Well, depositions are good just for that. Trial questioning has one purpose, is to convince a court or jury of, your side is right.
Right.
You don't ask too many questions. You don't ask one too many questions. Every attorney
Right.
knows, don't ask a question you don't know the answer to. You have to keep it
Or
interesting.
it may be that you find out that this particular, if you've got a number of parties in the case, that some of them are exonerated. They really shouldn't even be in the case. And that gives you really, if you're looking at it like I think we had talked about, in the scriptures, you want to settle on your way to court. This is one of those things where the lawsuits are not for harassment; they're for justice. And you may find out that somebody you sued if it's a group of people in an organization may have nothing to do with in the deposition, particularly the Texas Rules of Civil Procedure 202. That's the pretrial deposition, which is the specific purpose is to determine whether or not you even have a suit against them. Because the courts don't want you suing people that shouldn't be in court.
But in trial, the questioning has one purpose, is to convince the court or the jury.
Right.
But deposition questioning has many purposes.
Yes.
It's to gather information. It's to test your legal theory. Say, like, you've got a legal theory of sexual harassment, and you ask general questions. That they start out with general questions, and then the attorney who's deposing the deponent narrows it down to more relevant fact
Right.
questions.
So it's very broad, and then
it kind of turns into a cross-examination to get their admissions on certain things.
And we had recently done what's called it's a deposition in federal court in the bankruptcy code. It's a federal bankruptcy rule 2004, and it's called a 2004 exam. And the Chapter 7 trustee had deposed a party, and he did exactly that. And he did it he was a very new attorney, but he did it so well. He started out with very broad questions, and then he kept narrowing it down.
And that's what a good attorney does.
But basically, what he already knew what the answers were. He was trying to lock this person into those answers
Admissions.
for court, and because he knew that there was fraud. And I don't think that the deponent even saw it coming. He was so pompous. And what do they say? Pride before the fall. He was so arrogant that he was just answering these questions, and he boxed himself into answering the exact questions that showed that there was complete and total fraud. And really, it won our case for us.
Yeah, that's the goal of a good and see, that's why cases are finished in depositions, because they've got enough proof that everybody stands up and says, "Okay, I'm done here." The attorneys, "I'm done. We got this admission. Now it's over."
Yeah, and then how are you going to get around that? Once they've said it, it's under oath. It's coming in. There's no, oh, I changed my mind. I was lying. When are you lying? Are you lying here in court? Were you lying before? Are you lying now? If you lie, that's why the truth will always set you free. If you've lied in one place, you've lied. And perjury is actually a crime, but very few people get on the stand and lie and are charged with perjury, although they should be. I just think that the judicial system doesn't go after people that perjure themselves because there's just not enough resources.
Yeah, unless there's some high-profile person that they want to make an example out of and hope that they won't have to spend resources
like they do in
on
the government.
the other people. Yeah.
I will say this, though, that I've got a list of 4, and I want you to add to it if I've missed anything. The purpose for a deposition, to obtain critical facts regarding the case. For an example, how and when an injury occurred and who is responsible. And you had already, I
Like
think,
in a personal injury case?
alleged that, or actually probably specifically said that, to assess the strengths and weaknesses of the other party's case.
That's right.
As well as your own. And that goes toward the 202, the Texas Rules of Procedure 202, if you want to have and you have, just a little background on that. If you haven't filed suit and you're not really sure if you've got a case against somebody, you have to ask the court's permission to actually get a case number so you can depose them. You can't just randomly say, "I want to depose you," and don't have a suit. You have to actually have a case going. But if there's no case yet and you need to test the waters, then you'll actually file a 202 notice, and you get a court case number with the court so you can go forward with a pretrial deposition.
All right.
And the other side can oppose
or
it.
is it pre-trial or pre-suit?
I'm sorry, no, it's pre-suit.
Okay.
Pre-trial, but even before
Yeah,
that,
because
pre-suit.
they're all pre-trial.
Yeah, and we've done a few of those, and they usually do lead to a suit. But you're protecting yourself because people can sue you for suing them for no reason. That's just for harassment. Doesn't happen very often, but sometimes it does because people are very, what do you call it, luxurious, and they just want to sue. We've never been in that boat before in the 20 years I've practiced law. That's never happened. But the 202 exams are pretty good for that reason, particularly if you question whether or not you were trying to get information to see if a defamation suit exists or if an injury suit exists. You really do need to use that tool, and that's why the legislature has passed that provision. Now, and the third reason is to pinpoint specific knowledge and facts that a witness possesses. You may not want to call them to trial. It may be a waste of money to bring them to trial, particularly if it's a doctor, somebody that's in a profession where you don't want to pull them away from their work. If you can, I like the deposition on written questions better than a live deposition for that purpose, because you can ask questions to weed them out to find out if they're really a necessary witness. Generally, if your hunch is that they are, or if your client believes that they usually are. But
Right.
that deposition on written question will lead you into, that's the prerequisite to an oral deposition. Depositions and written questions are also kind of expensive. You usually get, I think, you told me you'd used them before.
Oh, yeah.
There's actually companies that you can hire that's all they do is they're sort of like a mill for them. They know the procedures, they get the people subpoenaed, they have everything in order so that it's admissible, but that people answer the questions. The problem we have with that is people, just like they do with regular discovery, they'll not answer the question because no one's in there holding them to it.
Right.
The fourth reason is to obtain a good sense of what the witness is likely to say in an upcoming trial.
Exactly. And then also you can see what kind of witness they are,
Mm-hmm.
not just what they're likely to say, but how they stand up under pressure.
Right.
You can be very nice as the deposing attorney, and you can get a little more aggressive with them
Right.
and see how they respond.
You had learned that with a client that we mutually shared. We believed that she would be a weak witness in trial, and she ended up being
She was
an
unbelievable in her
amazing witness
deposition.
when put under the fire.
Yeah, even the videographer
Over.
and the court reporter were saying,
Amazed.
"You're so
Because
wonderful."
She seemed so meek, and her demeanor was so, you couldn't really hold. She seemed to be very sensitive about a lot of
But
questions.
for our listeners, I want them to know that I remember her specifically telling me, because I think you did a hearing for her and she was really meek. I remember her specifically telling me that she talked to herself and talked to herself. She talked to herself in the mirror. She pretended like she was being asked questions, and she really mentally prepared for that deposition.
Right.
So I think when she was different when she was in court with you than when she was in
I
the
think
deposition.
she learned when she was in court with me, particularly. I mean, I'm never a mean attorney. I'm never going to,
That's
hold any-
true.
It's like if they did poorly because they were, and this happens all the time. I was just in a motion. It was a hearing to cancel removal for immigration yesterday, and my client was talking with him. He was very assertive and straightforward, and he answered all my questions. But once you put him before the judge, and the judge was just asking him simple questions that we had gone over, he was telling the truth. He seemed meek. He seemed afraid. You couldn't hear him. He wasn't assertive. It almost seemed like he was lying. It was like I didn't prepare him for the hearing in the way that I thought I needed to, because he was so assertive in person.
Yeah.
But the minute he got in front of the judge, he was completely different.
It's a different
So I believe
situation.
that our mutual client, when she was under the fire of court, she realized it was almost like learning to skate. She realized, I need to bone up on this. I need to practice.
And she did a great job.
Yeah, so she got a taste of doing it terribly, but she didn't lie, but she presented poorly. And then after that, she presented very well.
Yeah. Also, in a deposition, some advantages over trial is that you have to ask the question one too many because you really want to know the answer. It's not like at trial.
Right.
You can ask questions to preserve testimony. You already said that. And also, if you go down irrelevant, boring paths because you need to know if they lead to relevancy, that's okay in a deposition. In a trial, the jurors get bored, the judge gets bored, and so you need to know where that's going to go. We're going to take a quick break, and when we come back, we're going to talk about the actual deposition, how to get prepared for it, and what's going to happen in it.
Okay.
So, Toni and Cheryl, we're talking about depositions today. We'll be right back.
Hispanic Chamber Connections with Dr. Carlos Sanchez, president of the Woodlands Conroe Hispanic Chamber of Commerce, featuring event announcements, member highlights, and more. Tuesdays at 1 p.m., broadcasting from the heart of Conroe, Texas on irlonestar.com and Conroe's FM 104.5, 106.1.
Path to the Plate is a research-based education program that helps consumers understand how their food choices impact their health by making the connection to agriculture. Learning about how food is grown and produced, and how consumers can make better food choices for themselves and their families, Path to the Plate is all about dispelling myths and misconceptions. Find out more online at pathtotheplate.tamu.edu. We are Texas A&M AgriLife Extension, helping Texans make their lives better.
Lone Star Community Radio is ready for the summer. If you or anyone you know is looking for a summer internship, Lone Star Community Radio is a great place to learn the radio and TV business. Contact the station at info@irlonestar.com or call the station's message line at 936-647-3776. Lone Star Community Radio offers a great opportunity to those interested in learning about the radio world.
Health Center Southeast Texas is a federally qualified health center. We accept Medicare, Medicaid, and most major private insurances. For our self-pay patients, we have a sliding scale discount program available. Our health centers have qualified providers and staff striving every day to provide the best quality of care to our patients. Services offered are family medicine, behavioral health services, telepsychiatry, and pediatrics. We have 4 area locations. Look up the Health Center Southeast Texas online at hcset.com.
This is Rick, TRC. Every Tuesday on my show, Afternoons with Lone Star from 3 to 7, I play back-to-back classic rock hits. That's right. I like to call it a 2 for Tuesday or a 3 for whatever it is you'd like. Call the request line, 936-647-3776, or message me on Facebook, Afternoons with Lone Star, make a music request. That's right, you can do it. Here's what else. Go over to our website, irlonestar.com. Get the app on your phone. It's easy. You'll like it.
A Lone Star Community Radio is looking for those who are interested in hosting their own talk show, with monthly and weekly slots available on Conroe's FM 104.5, 106.1, and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the station message line at 936-647-3776 to take your first step into the radio world.
Welcome back to the Legal Connection with Toni and Cheryl. Today, Toni and I are talking about depositions. We've been talking about parties and notice and all that stuff. But Toni, right now I want to get into the basic deposition. All right, so you've been subpoenaed, you're there, or you've been called, you've been noticed, you're a party, you've been noticed, hey, I'm doing a deposition on this day and all of that. So when they come in, there's a court reporter that's there, and a lot of times it's videoed. We were talking about, Dick and Lone Star Radio considering offering that service, but it's very common that they're videoed. And so what happens is the deposing attorney sits across from the deponent and begins to lay the ground rules. And some of the ground rules are you speak loudly, you wait until the question, or if you've got a translator, the translator is finished, is complete before you begin your answer. The reason for these kinds of instructions is because court reporters can't get people talking over each other. They can't do 2 people at once.
And they get mad. They tell you about it.
They sure will. And make sure you fully understand the question before answering. That's a huge deal because so often very rarely will someone slow down and actually process what you're saying before they get ready to answer. You take a break. If needed, you just request a break if you're the deponent.
That's a good lesson in life, I think.
Oh, absolutely. And you can see that, I don't know, I'm sure you've noticed this too. My whole life, as soon as I started asking someone a question, I would see them blank out, the wheels start turning in their brain, they quit listening to my question, their mouth started to open, and they were ready for an answer. So they basically answered the question they thought I was going to ask, not the one that I asked. And it's really important.
That works a lot of times, but
I don't think it works. Yeah. And you, especially if what you're saying is going to be on the record because you're being deposed, make sure you understand the question.
Well, particularly in a lawsuit because they're asking you questions. And attorneys are tricky. They'll try to trip you up.
Well, they're trying to get you to say things on the record that they can rely on as an admission.
Well, I think like we were talking about before the show, I think that depositions would, again, I like to actually be in trial when I'm asking the questions, but I think that many attorneys that I've dealt with have sort of a harassing nature, and they want to have a gotcha, and they actually enjoy sort of needling you, and it's almost sadistic. A lot of attorneys, I'd
Which
say.
is why you really need to understand the question that they're asking. You need to pause, think about your answer, and answer. And also return to a question if you remember some additional information. You know, be honest. All right. Now, I hope that we get a little bit of time to talk about, as attorneys, how to prepare your witnesses for depositions, but be honest.
Be honest, but also remember that sometimes you do have rights not to answer, and we'll probably get into that.
And you should have an attorney there with you making objections if you're being deposed. You're going to be asked if you're on any medications. You're going to be asked if there are any conditions that impede you giving complete and accurate testimony. You're going to be told that you are under oath and you need to respond to my questions just like you would before a judge and jury. Do you understand that?
And it seems like a silly thing to say, but the truth is, if somebody wants to get out of what they said later on in the deposition, you have to lay that groundwork, because they'll say, oh, I was on medication that day, or they'll try to come back
And
to
if
it.
they do, the attorney says, I clearly ask you if you were on any medication that would affect your testimony, and you said no. So now you're saying you were. So you perjured yourself?
Yeah, and they're going to say, well, because I was on medication.
Yeah.
It's like my alcoholics when they get stopped by the police officers, and they'll like, have you been drinking? And then later on they'll say, well, you know, I was on medication. I didn't know to answer. And that kind of goes through a whole different, gambit where you're stopped. And I tell everybody, if the police officer stops you, just like in a deposition, just say nothing, please. You have the right just to show your ID and say nothing. But that's a different show.
And not true in depositions, because in depositions you have to answer. And
Exactly.
if you don't answer,
You're not under oath when the police officer stops you.
exactly.
And they try to trick you too. They'll say all kind of policemen can lie to you, whereas the person that's doing the deposition isn't going to lie to you. They're simply going to ask you questions.
Exactly. You're going to be sworn in. You're going to be under oath, and typically you'll be recorded.
Well, I take that back. They could ask direct questions that are not true to see how you'll answer, but even more important that you listen to the question.
As a matter of fact, a good attorney who's defending a deposition will come up with some sort of technique to help their client correctly process the question that has been asked of them. I've heard attorneys say that they pause, they take a breath, they think, they repeat the question in their mind, whatever.
Or say they don't understand the question, can they ask it differently? That's a lot.
Exactly.
And that if you take a pause in a deposition, that's not showing up on the transcript. You could pause for 5 minutes and it looks like you immediately answered it, unless it's a video. And remember, if it's a video, they're watching. The reason they do that is because they're watching to see whether your reaction is a lie or not. So, again, that's why the video ones have become so popular.
Right. I'll tell you something interesting. If you YouTube Texas depositions, oh my goodness, have you ever done that?
No.
Oh gosh, it makes us look terrible. But there's this one deposition. I think this
What,
guy.
attorneys?
Oh yeah. Well, yeah, just Texas. These attorneys are cussing and yelling, threatening to
Yeah.
go out back.
Oh, they
and-
do. I've been in so many depositions where it's almost like they're showboating. They stand up and they throw things around and they walk
Right.
out and they slam doors.
Threaten.
And I'm going to call the judge. And I had one attorney that I worked with for a while on a case, and he had all of his depositions in the court's settlement room, or the room outside
Breakout
the court.
rooms, yeah.
Because the judge was right there, where he could always ask the judge to come make a determination on whether something should be answered. That's just what he did. Not all attorneys could do that. This guy was pretty good friends with the judge, but I would say that if you asked, the court probably wouldn't deny you. It's a public facility.
Yeah, well, that's true. So you're gonna be sworn in. You're gonna be instructed that you're under oath, that you need to answer truthfully, And a lot of attorneys will just stand on that and reiterate that and reiterate that. And then when they feel like you're not answering truthfully later, they'll come back to that and say, you remember that you're sworn in, you're under oath. And it's scary.
Very much like trial, though. They'll say, oh, you didn't remember this, but you remember that. And like we were discussing before, you know, a lot of people use that Bill Clinton technique of I don't recall, or
what is
you
this?
know, you know, I don't.
Depends on what is this.
Yeah, mostly it's I don't recall, I can't remember, whatever. And for whatever reason, they're not answering the question. They're dodging it. And I have found that even in trial, a lot of times the judges don't care, which really bugs me. It's like, obviously they're saying they don't recall and they do recall. They're just using that. But that is an answer that will, if you don't recall, it's an answer to not answer the question. So that is a defense.
And so then what will happen is the deposing attorney will begin to ask you very general questions, very broad questions, almost like you're their witness at trial. I mean, because that's what we do at trial. We call our own witnesses and we ask them very broad, open-ended questions and let them talk and talk and talk. Based on your answers to those questions, they identify key points that go with their theory, like you were fraudulent.
But that you should be expecting those questions. So it's not rehearsing. It doesn't matter which side of the deposition you're on, but if that's what the case is about, certainly you already know how you're going to respond to those. It's the little questions that you're not expecting that are going to trip you up and the way they're asked. And a lot of times, and I think we discussed this too, they'll ask questions that have no relevance and they're completely inadmissible, but they're asking you things in this deposition that truly have no relevance to this case, but they're your personal business. And that's why you need an attorney. And those are the things that you need to be able to protect from getting to the public record, because a lot of times these depositions will end up in the public record. I can't tell you the number of times I've read about high-ranking presidents of companies who had venereal diseases, and it comes out in these depositions. And it's embarrassing, but there it is. And it showed up because it was an emotion to compel. And right there for the public to read forevermore, these people, you know, are probably cringing that it got filed and not set aside as confidential.
Terrible.
But that's what happens.
But let's talk about attorneys representing clients, parties, or non-parties in just a second. So they're going to ask you when you're being deposed. Okay, they're going to ask you broad, open-ended questions. Based on that, they're going to gather information. And then the deposing attorney will begin to lock down specific facts. And at the end of the deposition, they're going to try and get admissions from you. So just know that that's what they're doing. It's okay. You can be honest. You can tell the
if you're
truth.
telling the truth, it's not going to be a big deal.
Well, yeah, you need to be telling the truth because you're under oath. And so
it's when they twist the question that it's not the real answer. That's the problem.
That is the problem. And that's why if you're being deposed, you need to make sure that you understand the question. Okay, so let's talk a little bit about this. I'm the deposing attorney. You're the defending attorney, right?
I'm going to be I could be the deposee either way. It'll probably be
Well,
awful.
you are. Be both. You're both, and I'm the deposing attorney.
Ask me questions.
So, well, you've got one objection that you can make as the deposing attorney, right? That's objection form.
Right.
But I want our listeners to understand.
I thought there was two. There was form and one other one.
No, I can make one, and it's non-responsive.
Okay, non-responsive. Right.
Yeah. As the deposing attorney, I make the objection non-responsive. But as the defending attorney, you make the objection form.
And that being said, I've been in so many depositions where that's not followed properly.
Oh, it never is. But
They don't know the rules,
form, right. Form is pretty much every objection that you can make. And so I ask your client, okay, just, you know, where were you the night of the accident? You know, and where were you the night of the accident? You were home, right?
Yeah, objection form.
And then I can say to you, okay, what's your specific objection? Well, you're going to say compound question, right?
It's not specific.
Which one is
relevance.
my client answering? You know, and so I've just tricked your client, if I can, into giving one answer for two questions. So then in the end, I go back and say, well, she was saying yes to that. The one I wanted her to say yes to.
Your question is so broad. You don't know what accident unless it was defined early. I mean, that had so many objections to it, that one question, because just in the open, it could have anything you answered could hurt you because you don't know what the question.
Relevance.
It's not specific. It has to be very much tailored to what they want answered, particularly if it's a yes or no question. And opposing counsel is going to ask you questions that that the only answer is yes or no.
especially towards the end of the deposition. And here in Texas, we have 6 hours to do a deposition. So, I mean, man, after 6 hours, if
Now, you can get more, you can move to have more, but you shouldn't need more.
but I'm just saying, if you're the one being deposed after 6 hours
You're exhausted.
and you're ready to answer yes to anything, and that's when they really hammer
That's true.
in
That's why we have laws
and
against
get the
interrogations.
admissions. Yeah, and try and get the admissions at the end. But an example, if I'm the deposing attorney and you're the defending attorney, or then you're gonna I ask you a question, okay, and then you start to lecture me, like, okay, tell me about the night in question. Then they just start to lecture me. Say that's the dumbest question I've ever heard. Something. Tell me about the night in question.
Okay, you're asking me that question as the person being deposed or the attorney?
I'm the deposing attorney,
Okay.
and you're the deponent.
Okay, and you tell me about the night in question.
Yeah, tell me
I
about the
would
night.
say nothing until my attorney objected.
Okay, then I would say objection non-responsive.
Okay, and then my attorney would say, and I'm paraphrasing here, but basically, that's objection confusing because you're not even asking a question. What night in question? Be more specific.
At the beginning of the deposition, they're going to be asked. The deponents are going to be asked those very open-ended, broad questions. Tell me about that. Tell me about that. Tell me about your education. What happened
Yeah,
after
and then
that?
that's kind of like anybody else that you're meeting. You're kind of opening up sort of a friendly dialogue with them, and you're not going to be lying about your education. And so they're also testing you there. How good is your memory? So, but the truth of the matter is, in every deposition I've been in, if you've got somebody that's telling the truth, they have nothing to hide. You just have to be really careful because they're going to ask you questions that truly are, they want a yes or no answer, and it's not a yes or no answer. There's usually some gray area involved in it, and you simply can't. It has to be just like an admission. You have to say, I can't answer that because either I don't know the answer because I'm not the person that has the information.
Right.
And then they'll ask you to speculate. Well, that's going to be an objection,
Right.
speculation. Or you may know the answer and you don't want to let them know what the answer is, particularly like in a crime. Where were you the night in question? Let's say they asked it the correct way. On the night of May 21st, 2016, and this was when the murder occurred at or near 8 o'clock, which is when they assumed that the people saw people running from a scene where there was a fire or there was a murder or something. Where were you? Okay. So that's a very specific question. Okay. It's not yes or no. And they can say, I don't recall. Well, isn't it true that you were at, 1012 Reading Street at your home watching? And that's a compound question, objection compound. Isn't it true as you're at your home? And so you're going to keep tailoring it till you get the answers you want. You're going to pull it out of them depending on which side that you're on. That's just what that's what any attorney is going to do. They're going to keep pulling at you to get the information that they need. And it's not even really a skill. I mean, people do this in real life.
It's a technique. Yeah.
Some people are born litigators and people that can get answers out of people. Some people aren't. But that all being said, you're just trying to get to the truth generally. But sometimes that question's not even relevant. So you're just like, I can trying to think of questions right now. People ask you about, I'm trying to think of the last deposition I had. Just think of one where somebody asked you something that was completely ridiculous.
Well, you can do that in a deposition.
Yeah, you can ask ridiculous questions that have no
anything
bearing.
that might lead to something that's relevant.
And they can ask you about, isn't it true? Let's just go out on a limb here.
Yeah.
Isn't it true that, and this is not true, but I'm just going to throw it at you just to show you how humiliating it can be. Isn't it true that you had an abortion in 1980? No. Well, and then they start trying to make it true by asking you questions when it's simply not true. And then it makes you frustrated because you want to yell back at them. Oh, that's not true. And then
they're trying to ruffle you.
They're trying to ruffle you. They're asking, and they can do that in a deposition. That's why, you have to have a counsel present to object to relevance, and even relevance isn't going to work. And that's when you answer it. They calm you down if it's upset you, and they'll say, answer the question, no. And you want to give short answers. You don't want to elaborate. People get in a lot of trouble when they say too much.
So you as the defending attorney, you can make 2 objections, leading and form, and then the deposing attorney is non-responsive. But, I was in a deposition not too long ago where I kept objecting leading. I was defending. And I was defending the deposition, and then that attorney gave me a list of 5 cases that said, you can't object to leading anymore. Read these cases. And I was like, whatever,
Yeah.
you know.
Ridiculous.
Yeah. But so talk about the importance of having, if you're being deposed, the importance of having an attorney represent you.
Well, I wish I had a list of things in front of me, and I don't. I can only tell you just for the number of depositions that I've been in, and there hasn't been many where people have not been represented.
Yeah.
They have really sunk their ship. That's the best way to
Because
put it.
they're just kind of a sitting
Because
duck.
they get in there, and if they're showed up without an attorney, and these are not usually, if somebody doesn't have the money for an attorney, they can go to Catholic Charities. They can go. An attorney will generally step up to the plate and help you
Yeah.
file a motion as to why it should be quashed and give you time to prepare, that to get the documents, or to go over why you're even a witness. There will be an attorney out there with one of the legal facilities that we have there that will help you. But if you're the type of person that's, I don't want to say you, but if somebody is deposed and they're arrogant enough to think that they've done this before, they can
Yeah,
do it.
I agree.
Whether they're an attorney or not, that is the high before the fall. Even if they're upset by it, the attorney's going to be there to object. It's really hard to object if you're pro se. You really have to have somebody to do it for you, because you're not thinking about what the objection is. You're thinking about the answer to the question.
Exactly.
And it could be that it's completely irrelevant and they're just trying to ruffle you. The attorney is going to be there like the person at the bar. If there's this, I don't go to bars very often, but they're there to calm you down and to be the voice of reason for you. That's what your attorney's going to do. And they have the legal background to know what the objections are to protect you. And perhaps not to protect the other side, but to protect you from saying something that may not necessarily be untrue, but it's not, you didn't understand the question.
Yeah, absolutely.
And an invasion of your own privacy.
Yeah, And so as the deposing attorney, I just want to say that it's super important, if you're being deposed, that the attorney prep their witness, go through all the questions that are probably going to be asked, talk about all the discovery that they've submitted. And sometimes this can take days. If it's a corporation that's being deposed and they've appointed a relevant person, I can't remember what that person is that they call, but it's the one with knowledge of the issues and situations. They need to spend at least
a fact witness.
they need to spend at least a day with their attorneys. And I hear attorneys say that they're never the client never complains about the bill went on the days that they spent in witness preparation, even if it took them a week to go through 5
well, it's
witnesses.
also helping the attorney, because the attorney's collecting information and knows better questions to ask for the deposition, depending on whether you're the one defending it or giving it. Now, I wanted to go over briefly about the Apex Doctrine, just because.
I think we need to talk about our guest next week.
Oh, okay. How much time do we have?
We got like 2 minutes, a minute and a half.
Okay. All right. Our guest next week, what do you have to tell us about Lemonade Day?
Well, I am excited. We're going to have.
We've been talking about them. They're building up the momentum and the excitement about them being here.
Yeah.
We know that we all need to learn about how to run a business and corporations, and Lemonade Day has helped. I'm sure a lot of people that had Lemonade Day as kids have gone on to do better in school and make better decisions.
Absolutely.
It's just like depositions. It's the preparation for something to come and taking all the mystery out of it. So
yeah,
anyway,
and so it's going to be 12 to 1 next week on our show, and we're going to have the president of the company.
The president of Lemonade Day. Well, it's a nonprofit charity. But to help people. But we don't have the guy that started it, the founder. But we're going to have the president. He's going to tell us all about it. Get your kids involved. Get your adults involved. Aunts, uncles, everybody.
And
wants
when
to
is
learn how to run a
Lemonade
business.
Day? Do you remember? Is it it's May 2nd and 3rd?
I thought it was right around Mother's Day.
Okay.
But they're going to tell us next
Yeah.
week for sure.
All
the
right.
day that it actually
Okay, guys. Thanks for listening. Remember,
starts. Serve God by serving others.
see you next week.
Thanks for checking out this show on Lone Star Community Radio, Montgomery County's community radio station. This show is owned and produced by Lone Star Community Radio and recorded live from the LSCR studios in downtown Conroe, Texas. For more information about the show, to be a guest, or to sponsor, just contact the studio at 936-647-3776 to leave a message, or email us at lscrstudios@gmail.com.